Looks like the numbers have stopped adding.
Okay. Hello, everyone. Welcome to the WTO Public Forum number 75. My name is Patricia Ranald, and I'm the convener of the Australian Fair Trade and Investment Network. And I'm also an honorary research fellow at the University of Sydney. This session will discuss the substantive and legal implications of the Plurilateral Joint Statement Initiatives, or JSIs, for the multilateral trading system and for the WTO as an international organisation. This is one of the most pressing questions that has arisen since the ministerial meeting MC11. And while the proponents argue that this approach will revitalise the negotiating function of WTO, many, mainly developing countries, argue that it will weaken the multilateral trading system. The participants in these sessions have been actively engaged in this debate, especially from the perspective of developing countries. So we aim to canvass those arguments from diplomatic, academic, and intergovernmental NGO perspectives and provide a robust analysis to assist deliberations on the JSIs amongst WTO members and participants. I'd like to introduce the panelists. We have three very impressive panelists. The first one is Ambassador Zalela Mulumbi-Peter, the permanent representative of South Africa to the World Trade Organization. In 2020, she was appointed chair of the TRIPS Council and has served as South Africa's chief negotiator and deputy director general in the International Trade and Economic Division and at Department of Trade and Industry since October 2014. So she's worked extensively on trade, intellectual property rights and investment policy. And she has also led South Africa's trade negotiations with various partners, including the EU, the UK and Mercosur, and at the regional and African continental level. She has also led negotiations on behalf of South Africa in various other multilateral platforms. Our second panellist is Dr. Jane Kelsey, who's Professor of Law at the University of Auckland, New Zealand, specialising in international economic regulation. She has a law degree from Victoria University of Wellington, Oxford University, Cambridge University, and a PhD from the University of Auckland. She has worked on WTO issues since the Brussels ministerial meeting for the Uruguay round in 1990. In addition to research and teaching, she advises and provides pro bono training for developing country governments and civil society on matters relating to the WTO and other free trade and investment negotiations. Our third panellist is Professor Abhijit Das, the head of the Centre for WTO Studies in New Delhi. He has more than 2 decades of experience in international trade in various capacities, including 5 years in the government of India. He's participated directly in many multilateral and bilateral trade negotiations, including the Doha round. And he has also worked on the UNCTAD India program and headed this prestigious UN project for 3 years. He's jointly edited books on the WTO, on international trade, on dispute settlement, on India's WTO participation and India's trade liberalisation, and on the Trans-Pacific Partnership. And he's a regular commentator in the media. So having introduced our 3 excellent panellists, each will speak for 8 minutes about the issue and then in reverse order about what they recommend should happen as a result of their analysis. And I'd like to introduce the first speaker, Ambassador Zalela Mulumbi-Peter. Thank you.
Thank you very much, Pat, and good morning to the panelists as well as to the participants to this session. I think I'll start by clarifying first what our perspective is in terms of what the WTO was established for as entailed in the Marrakesh Agreement. The WTO was established as a forum concerning multilateral trade relations, and we, together with India as well as Namibia, submitted a paper on the legal status of the JSIs. And the key objective of the paper is to remind everyone, including all WTO members, of the legal architecture that governs the functioning of the WTO. And in our view, it is critical to preserve its multilateral character. I think it's also important to contextualize this discussion in terms of the implications of the current pandemic. For us, the pandemic is a sharp reminder of the importance of global solidarity and global cooperation in dealing with global challenges that face all of us. And the challenges that are facing humanity are, of course, not limited to this current pandemic, but also include issues such as rising inequality, both within and between countries, as well as poverty, as well as food insecurity. What this says to us is that all of these necessitate that we avoid measures that will undermine or fragment the multilateral trading system. And I want to emphasize that we are not questioning the right of any member to meet and discuss issues of interest among like-minded countries. We do believe that any group of members may discuss any issue. However, when discussions turn into negotiations and their outcomes are sought to be formalized into the WTO framework, we believe that it can only be done in accordance with the rules of procedure for amendment, as well as decision-making as set out in the Marrakesh Agreement. It's also important to note that the plurilaterals are provided for in the Marrakesh Agreement and are included in Annex 4 to the agreement. However, there are specific rules that need to be followed to integrate these into the WTO framework. It's also important to note that the Marrakesh Agreement states that the Ministerial Conference, upon the request of members a party to an agreement, can decide exclusively by consensus to add that agreement to the said Annex 4. And the provisions in the Marrakesh Agreement were carefully negotiated and are a result of the experience that is acquired in the GATT, which was characterized, especially after the Tokyo round, by agreement on a number of plurilateral codes. And there was recognition in our view that these plurilateral codes created a fragmented system of rules. In respect of some contracting parties, the GATT rules were applicable, while in respect of the rest, the GATT rules and the rules of the plurilateral codes were applicable. This created considerable complexity in determining what obligations were applicable in respect of which contracting party. And the preamble of the Marrakesh Agreement clearly articulates the members' vision for the WTO, and it is to develop an integrated, more viable and durable multilateral trading system. Article 2.1 of the Marrakesh Agreement also states that the WTO shall provide the common institutional framework, and I underline common, for the conduct of trade relations among its members. Article 3.2 states that the WTO shall provide the forum for negotiation among its members concerning, and again I underline, their multilateral trade relations. It provides for consensus-based decision-making as enshrined in Article 3.2, Article 9, Article 10, and also Article 10.9, as well as procedures for the amendment of rules which are articulated in Article 10. The Marrakesh Agreement, therefore, does not make provision for the so-called open plurilaterals, or what is now termed flexible multilateralism that some are now advocating for. Therefore, any suggestion that when offered on an MFN basis, no consensus is required for bringing new rules into the WTO, in our view, is legally inconsistent with the fundamental principles and procedures of the Marrakesh Agreement. Importantly, new rules cannot be brought into the WTO through amendment of members' schedules. sometimes there is reference that is made to the telecommunications reference paper as justification for the JSIs. We want to state categorically that as part of the package of the Uruguay round outcome, there was a multilateral consensus and a formal mandate for the negotiations of the telecoms reference paper, including agreement on inscribing outcomes into schedules without an amendment procedure. So this decision was taken through a multilateral decision. In our view, there are systemic and developmental implications that are inherent in the JSIs. And in our view, what this does is to subvert established rules, as well as the foundational principles of the Marrakesh Agreement. And they risk eroding the integrity of the rules-based multilateral trading system. They create a precedent for any group of members to bring any issue into the WTO without the required consensus, which in our view is especially of concern to developing countries. Because what this does is that increasingly we see disregard of existing multilateral mandates and marginalization of issues, which of course, as difficult as they may be, those issues are critical for the multilateral trading system to be inclusive. And such issues include agriculture, includes the developmental mandate as entailed in the Doha Development Agenda. And what it does is to undermine the balance that is already established in the WTO in terms of agenda setting, because the issues to be discussed in the WTO are agreed by consensus, and that allows for balance in terms of those issues and to ensure that we have a multilateral trading system that addresses issues of interest to all. And it also undermines the negotiating processes as well as outcomes. And as I said, as I conclude, the risk is the fragmentation of the system and also the undermining of the multilateral character of the WTO. And it seems to be taking us back to the gut experience that we all agreed when we established the WTO is not suitable in terms of creating a predictable, equitable multilateral trading system. Let me stop there, Pat. Thank you.
Thank you very much. Our next speaker is Dr. Jane Kelsey. Jane.
Thank you, Patricia, and good evening, good morning to everybody. As we've been watching the JSIs unfold, especially since the MC11 in Buenos Aires, we seem to be seeing the same rather cavalier attitude from the proponents that we saw with the Trade and Services Agreement, TISA, where we had a subset of WTO members launching negotiations on a topic that they've been unable to advance at the WTO, and then say, well, we can work out or work around the questions of the legalities if and when we reach an outcome. The difference, though, from TISA is that this time it's being done inside the WTO. And equally disturbing, the WTO Secretariat and the new Director General are supporting these unauthorized negotiations and potentially the adoption of the outcomes when they are inconsistent with the fundamental rules of the international organization that they have the responsibility to administer and protect. Now, I've set out numerous reasons why the JSIs lack legal legitimacy in several documents, which I think Pat as moderator will give you links to. One of them is a memorandum responding to an opinion from Hamid Mamdouh on the legality of plurilaterals generally, not just the JSIs. The second, which was just published yesterday, is a briefing note responding to Hamid Mamdouh's strategy for the adoption of the investment facilitation JSI in the WTO. And there's a further brief on the 27th of December Services Domestic Regulation reference paper that will be published early next week. So let me just pull out some of the key points from those papers. Fundamentally, because the WTO is an international organization, it can only do what its constituting instrument, the agreement establishing the WTO or the Marrakesh Agreement, allows it to do. And as the ambassador has pointed out, Article 3 sets out its functions. And paragraph 2 of Article 3 prescribes it as the forum for negotiations amongst WTO members concerning their multilateral trade relations on matters dealt with in the annexed agreements, GATS, TRIPS, or on new issues if approved by the ministerial conference. And I understand Professor Das will address this more specifically. My point here is that the Marrakesh Agreement does not mandate a self-selecting subset of WTO members to launch negotiations amongst themselves, either on matters covered in Annex 1, the existing agreements, or not covered by them, because that is outside Article 3.2, which is what mandates WTO negotiations. Nor does Article 7 of the Marrakesh Agreement anticipate the diversion of WTO budget and resources to support negotiations that have not been authorized. Now, when we look at the three main joint statement initiatives on electronic commerce, services domestic regulation, and investment facilitation, we actually see that each of them is already subject to consensus decisions by members that have been taken pursuant to the WTO's rules. So ECommerce is being addressed under the 1998 work program through the designated councils and the Committee on Development. It does not include a mandate to negotiate, and indeed members did not agree to grant a mandate at the MC11 in 2017. So the JSI on e-commerce is seeking to go around a properly made decision by the members of the WTO. The September 2021 reference paper on services domestic regulation disciplines, just released, says explicitly that it is pursuant to Article 6.4 of the GATS. But Article 6.4 of the GATS provides for negotiations on any necessary disciplines, necessary being a precondition on which there is no consensus, to be conducted in the Working Party on Domestic Regulation, not through a subset of members that calls itself a joint statement initiative. As for investment, there is actually a negative mandate under the July 2004 package. It says work towards negotiations on investment will not occur within the WTO during the Doha round. That round is still formally in play. So we have the three JSIs that not only don't have a mandate, but are undermining the formal processes that are mandated. Fast forward from there to the adoption of concluded texts out of the JSI. Equally problematic. Two main pathways have been identified. The first is to adopt them as new agreements. And the Marrakesh Agreement sets out the terms for doing so. A new agreement can be added to Annex 1 multilateral trade agreements by consensus, as happened with the Trade Facilitation Agreement. But the agreement must be genuinely multilateral in that it alters both the rights and obligations of all members, which the JSIs as plurilaterals do not. If it is a genuinely plurilateral agreement, where obligations and benefits are restricted to the parties, it can be added to Annex 4 only explicitly by consensus. Now, clearly there is no consensus for adopting the JSIs either way. And Hamid Mamdouh acknowledges in his paper last month, that this is not actually an option because he proposes the adoption of a new annex, Annex 5, for so-called open plurilaterals. But doing that, again, would require consensus. So the second option, which I call the Trojan horse, is designed to bypass the problems of the amendment process under the Marrakesh Agreement and insert the new rules in the JSI texts into members' GATS schedules as additional commitments under GATS Article 18. That, I suggest, is a cynical misuse of schedules. The JSIs propose new rules. General obligations and disciplines in the GATS belong to Part 2. Changes to that requires an amendment. Part 3 and 4 of the GATS, including Article 18 additional commitments, applies to specific sectoral commitments and their progressive liberalisation. Schedules cannot be used to insert general rules that should be adopted through consensual amendments in Part 2. The post-Uruguay round, financial services and reference paper on basic telecommunications do not provide precedents for this use of schedules, as the ambassador pointed out. They were both by mandated consensus decisions, and the decisions set out very specifically how they were to proceed. Furthermore, they were sector specific. So I suggest, unfortunately, that adoption of the JSIs through schedules would actually be an exercise of bad faith by members as a means clearly designed to bypass the organization's rules. And indeed, in the paper last month, Hamid Mamdouh himself has conceded that an investment facilitation text cannot be adopted by either a new agreement or through GATS schedules. There are many more reasons he cites for this, but it confirms that the JSIs have been embarked upon by WTO members without first considering their legality. So let me conclude by saying that there is a real concern here that the kind of approaches that are being taken are a political strategy pursued by countries that proclaim allegiance to a rules-based system, but are acting in total disregard for the WTO's own rules. The systemic consequences of that are serious, as the ambassador said, but there are further legal issues which I'll pass on to Professor Das to address.
Thank you very much, Jane. And I'll now welcome Professor Das to speak.
Thank you, Chair. At the outset, let me mention my sense of profound gratitude to Professor Jane Kelsey for organizing this session and inviting me to participate in it. I'm particularly privileged to be in very august company. Many of the points which I wanted to say have been touched upon as well as elaborated. Nevertheless, at the risk of repeating some of the points, here I go. I wish to make 4 or 5 very broad points. The first point is that WTO favors multilateral approaches to trade issues. The preamble to the Marrakesh Agreement is fairly clear on it. It articulates the resolve to develop an integrated, more viable and durable multilateral trading system. It doesn't say a plurilateral trading system. The word is very clear, multilateral trading system. This view has been reinforced by the panel in the US shrimp turtle dispute, where the panel observed that, and I quote, by its very nature, the WTO agreement favors a multilateral approach to trade issues, unquote. The second point that I wish to make is that providing a legal blessing to the JSIs would be a step in the wrong direction and would be contrary to other parts of the preamble of the Marrakesh Agreement. As I've already mentioned, the preamble to the Marrakesh Agreement talks of developing an integrated multilateral trading system. Now, the reference to an integrated multilateral trading system clearly highlights the concern of GATT contracting parties arising from the fragmentation of the multilateral rules on account of the various Tokyo Round plurilateral codes, an issue that was alluded to by Ambassador Goleva. Now, this is also evident from the observation of the appellate body in one of the earlier disputes at the WTO. In the dispute Brazil desiccated coconut, the appellate body observed the following, and I quote, "The authors of the new WTO regime intended to put an end to the fragmentation that had characterized the previous system. This can be seen from the preamble to the WTO agreement, which states in pertinent part, resolves therefore to develop an integrated, more viable and durable multilateral trading system encompassing the general agreement on tariffs and trade, the results of the past trade liberalization efforts, and all of the results of the Uruguay round of multilateral trade negotiations." Quotes closed. Very clearly, even the WTO panel, as well as the appellate body, uphold the perspective that WTO favors a multilateral approach to trade issues. Let me delve further and look into the aspect of functions of the WTO. As Professor Jane Kelsey mentioned, the functions of the WTO are specified in Article 3.2 of the Marrakesh Agreement. It is relevant to examine whether the WTO is a forum for multilateral negotiations or plurilateral negotiations. Another relevant question in this context is whether the WTO envisages negotiations among all its members or allows negotiations among a subset of its members. Article 3.2 provides considerable guidance in respect of both these questions. The first sentence of Article 3.2 specifies that the WTO is the exclusive forum for negotiations among its members concerning multilateral trade relations in matters dealt with under the agreements included in the annex. Thus, it clarifies two issues. First, who negotiate at the WTO? And second, what is the nature of negotiations? Addressing the first question, Article 3.2 first sentence clarifies that WTO provides the forum for negotiations among its members and not for negotiations among a small group of its members or among subset of its members. So clearly, again, we see a preference for multilateral negotiations as distinct from plurilateral negotiations. On the second question, the mention of multilateral trade relations makes it amply evident that the negotiations have to be multilateral as distinct from plurilateral negotiations. Now, similar conclusions can also be drawn from the second sentence of Article 3.2 of the Marrakesh Agreement. We are seeing a lot of legal creativity in attempts by the proponents and their cheerleaders to see how best to integrate the outcomes of JSI into the WTO. One of the most creative attempts has been in respect of claiming that the so-called open plurilateralism provides a pathway for integrating JSI outcomes into the WTO. We have often heard the argument that the outcomes of JSI can follow the example, can follow the precedent set by the Information Technology Agreement ITA and ITA expansion. However, from multiple perspectives, this argument is clearly flawed. Both the ITA and ITA expansion involved changes in schedules of tariff commitments. The outcome of JSI negotiations are likely to involve substantive rules, and substantive rules cannot be inserted in the existing goods or services schedule. That would be undermining the fundamental difference between commitments taken through the schedules, and on the other hand, substantial rules. So this distinction between what can be inscribed in a schedule and substantive rules, that distinction must not be blurred, although the attempt by the proponent appears to be to precisely blur this distinction. A final point from my side: both Ambassador Koleva as well as Professor Kelsey have very eloquently mentioned the downsides of the JSI outcomes. Let me add my 2 bits to it. Now, acquiescing to the integration of JSI outcomes into the WTO will substantially erode the ability of developing countries to pursue issues of their interest at the WTO. From the perspective of negotiating dynamics, this has grave implications for setting the agenda for future trade negotiations. If the proponents of the JSI initiatives succeed in getting their outcomes integrated into the WTO through means more foul and less fair, then in future, this route is likely to be perhaps the most important channel for outcomes at the multilateral trading system. With the erosion of initiation and undertaking negotiations based on a multilaterally agreed agenda, most developing countries would find it almost impossible to pursue issues of their interest. This will definitely diminish their stake in the system. And once their stake in the system is diminished, clearly the continued viability of WTO as an institution, intergovernmental organization that seeks to promote the interests of both developed and developing countries would really be called into question. So I'm going to stop at that. Thanks a lot.
Thank you very much, Professor Das. Now, it's been suggested that the way we proceed now is to get each of our speakers to briefly summarize in less than 5 minutes what they see as the next steps or what should be done as a result of their analysis. So could we start with you, Professor Das? Could you just summarize that?
Thank you, Chair. I'll take less than 5 minutes. The first point from my side: ideally, in respect of at least 2 of these issues, there are multilaterally agreed mandates. In respect of domestic regulations, we have the Working Party on Domestic Regulations, WPDR. In respect of electronic commerce, we have the 1998 Work Program on Electronic Commerce. For the sake of ensuring integrity and continued viability of WTO as a multilateral trading system, it would be important that the JSI proponents try to bring their issues through the multilateral channel. I think that should be the way forward. In case that is not possible, which seems to be the situation at this juncture, then new rules have to be, if the new rules have to be integrated into the WTO, then the amendment procedure as laid down in Article 10 must be adhered to. In other words, in accordance with Article 10.9, if a new plurilateral agreement has to be included in Annex 4 of the Marrakesh Agreement, that should be done exclusively by consensus. However, if the proponents fail to do that, then they would be opening a Pandora's box. And once that Pandora's box is opened, we do not know where it will end. So I'm going to stop at that. Thank you again.
Thank you. Jane, Dr. Jane Kelsey, do you want to summarize where you think things should go from here?
Yes, thank you, Patricia. I want to talk a bit about the Pandora's box. because I've been thinking of the ways that if these JSIs are pursued, they can be challenged. And I think there are 4 pathways. One is in the relevant committees whose functions the JSIs are usurping. But they can also and should also be challenged within the JSIs themselves. Participants in next week's scheduled discussion of the investment facilitation group, for example, are being asked to consider a series of questions framed around the recent paper by Hamid Mamdouh on how to integrate it into the WTO, which he thinks will be very difficult. So they need to reflect on whether they want to remain involved in an initiative that is clearly contrary to the institution's rules and that has serious implications, especially for developing countries. The second option, which is the process if the schedules mechanism is used, is to make full use of the objections to the certification of changes to schedules. Now, that is not easy because the certification process is solely concerned with recalibrating the sectoral commitments that members have made in the request and offer negotiations. So it's specific around sectoral commitments. But that restriction also makes it very clear that schedules are not intended for the adoption of rules because they can't be subject to that kind of calibration. And that should lead to more systemic discussions within the Council on Trade and Services and the Committee on Specific Commitments. The third option is for members to ask the Ministerial Conference or the General Council for an authoritative interpretation under Article 9.2 of the Marrakesh Agreement, interpretation of the term multilateral and multilateral trade relations, which are now being given a very elastic framing, or the provisions under Article 3.2 regarding negotiations, or Article 20 of the GATS on schedules. Now, an authoritative interpretation requires recommendations from the relevant councils, which would need to discuss these matters. And I doubt that there'll be consensus amongst them, but at least it would force the legal issues out of the shadows to be debated on their merits. And finally, there may well have to be formal disputes for breaches of the Marrakesh Agreement and of the GATS. In the current context, of course, in the WTO, such disputes may languish for a long time, whether alleged breaches of the WTO rules within the WTO itself means that any certification of schedules can be set aside pending a ruling on whether in fact they're legal is a question that lawyers need to consider. But let me conclude then by asking, is any of this scenario where the WTO and the new Director General want the WTO to end up? Are the only options, as someone was quoted as saying yesterday, fragmentation of the WTO or its irrelevance? That's a terrible choice. Because if that's what's on offer from the JSIs, we know who will be the winners and who will be the losers from that unequal process. And that is a very serious question that developing countries in particular who are participating in the JSIs need to consider before they go any further. Thank you.
Thank you, Jane. And finally, Ambassador, would you like to indicate where you think things should go from here?
Thank you very much, Pat. I think this issue of the legal question about the status of the JSIs and how they can be integrated into the multilateral trading system is an important issue, as Jane and Abhijit have highlighted, that developing countries must really think through in terms of not only the systemic and developmental implications, but importantly, what does that mean for the legal architecture of the WTO? In the paper that we prepared, that I referred to, and we prepared with India as well as Namibia, which is WTGC W819, we do give options. We took a progressive approach as we raise these questions in terms of how we see the provisions of the Marrakesh Agreement, and some have been referred to by both panelists. I will just also, in terms of the risk of repeating, but I think it's worth repeating those options that we have put forward to the members. One, they can seek consensus in terms of Article 10, and which would mean that they would seek consensus among the whole WTO membership, and then get the new agreements included in Annex 4. That could be one option. Or they could conclude the outcomes and then ensure that the outcomes are outside of the WTO framework. And we've had a number of cases in terms of regional trade agreements, plurilateral trade agreements, or even in terms of TISA. So that could be one option, that whatever outcome that they have would be outside of the WTO framework, and of course notified to the WTO in terms of the normal regional trade agreement processes. Or because we hear that members are now talking about this flexible multilateralism. If that is the direction that members want in terms of going forward, then they can seek amendment of Article 10 of the Marrakesh Agreement so that there is a process of establishing this flexible multilateral trading system. But of course, that doesn't come without risks, because once you have flexible multilateralism, what that means for developing countries is that increasingly the multilaterally mandated issues will be marginalized. They will remain in the periphery, and issues of interest to some will be those issues that will move. So we therefore will end up with a fragmented multilateral trading system that surely will not serve the interests of all, because a group of members based on issues of interest will then meet and conclude agreements among themselves. So the question would be, what is the value then of the multilateral trading system to the whole WTO membership? Because at the end of the day, I think we do recognize for developing countries that the most important value or benefit we get out of the multilateral trading system is that we are able to have the same voice. We are able to define and determine, even with this multilateral trading system is increasingly difficult, but at least what we are able to do is to ensure that we set a balanced agenda that serves the interests of all. So if we have a flexible multilateral trading system, that will be eroded, and there's a huge risk that we need to really look at. But we also appreciate and welcome the fact that the issues that we've raised in the paper around the legal architecture of the JSIs is now a question, unfortunately, after the fact. But what is important is that the JSIs are now looking at this. We heard yesterday from the chair of the Investment Facilitation JSI that he has sent guiding questions to members to reflect on this issue. And we are happy that it's now an issue that the whole membership is looking at, because it does present systemic risks for the whole system. And it is important that we reflect on it, and then a conscious decision is taken in terms of the way forward. And I find the idea that Jane has just put forward of authoritative interpretation interesting. I think it's something that is worth considering because it will be important to look at how we come up with an outcome that will preserve the multilateral trading system and a rules-based trading system, because our concern is that the approaches that we see seem to be undermining the very rules that underpin the multilateral trading system. Thanks, Pat.
Thank you very much. I'll now, we have a number of questions which are, have been written, and I'll try to group them and read them out. We've got about 15 minutes to answer the questions. Could I just say that I have posted as an answer to one of the questions, Jane's, the references to Jane's papers. I'm not sure if they're completely visible to everyone who's watching. I've also posted them in the chat in the Zoom. So I would appreciate it if our technical person in the CR room could ensure that those are visible to all the participants. But I'll start with, there are two questions asking, can the legality of the JSIs be taken up in the dispute settlement system? So I'd ask the panelists to address that one first. Who wants to?
If I make an entry and then I'll hand over to Abhijit, perhaps. This is quite a novel situation because most disputes that we see are about measures that have been taken by a member at a national level. And so to have claims that members have breached their obligations in the WTO, either under the Marrakesh Agreement or in particular under the GATS, is a novel situation. I'm quite convinced that the legal arguments show that they have. We have a dysfunctional dispute settlement system, so whatever a panel decides, I would imagine this matter would go on appeal and will then sit in limbo for as long as the appellate body is in limbo. And I think the key legal question that some of us will be looking at is if they adopt a process for adopting the JSIs through schedules, and those schedules end up being certified under the internal procedures, can that be set aside pending a challenge to the legality of that decision? And so this is kind of uncharted territory from my viewpoint, but I think it's critical to the WTO. But Abhijit has had more to do with dispute settlement in practice than I, so he may have a better answer.
Thank you, Jane. Unfortunately, I do not have a better answer. I'm almost as perplexed as many others. But I do think that, yes, there is a window of challenging the JSI outcomes if they are sought to be integrated through the schedule route. We could certainly attempt to claim violations under GATS and of course under Marrakesh Agreement as well. But Jane, as you said very pithily, with the appellate body being in the limbo, appeal to the void would really not take us anywhere through the legal channel this way. But certainly this is a route that must be explored. All avenues must be explored. But at the end of the day, some of these issues might require a resolution at the political level as well. So we must be cognizant of that channel in particular, apart from the legal route.
Thank you for those answers.
And maybe just to add a few points, I think both Jane as well as Abhijit have covered the challenges with the dispute settlement system as we currently have it. But also I think it's important to note the challenges that developing countries have raised with regards to the accessibility of the dispute settlement system for developing countries. So it's not an easy route, especially for the smaller members in the WTO. If you look at how or who utilizes the dispute settlement system more, I think that already gives a sense of the imbalances. But also, of course, the fact that you now have a dysfunctional appellate body, and increasingly that's what we see as well, that members where the panels have found against them are now appealing into the void. So you don't have an efficient system of resolving disputes in the WTO, and it's a crisis that members need to address, and we hope that MC12 will find not a resolution, unfortunately, but at least a pathway that will ensure that we have an effective enforcement system. But I think for this purpose, it probably would not be an efficient way of resolving these legal challenges. What we think would be better would be for members to confront this question so that we are able to find a mechanism that works, but importantly, a mechanism that preserves the multilateral trading system. Jane has also highlighted the challenges in terms of objections to the certification process. So again, that is also not a clear-cut mechanism, because you are not talking about contravention of rules in terms of a specific sector where you can exchange concessions among members. So there are intricacies that are also complicating following that route. So as I say, the best mechanism would be to confront the legal question. Thanks, Pat.
Thank you. I've got a couple of questions regarding MFN and the JSIs. Could the inclusion of MFN provisions create more support for them, or could it in fact be used? And I've got another question which I'll combine with that one, and that is in relation to the use of WTO resources for the JSIs and the role of the Director General. And given the discussion about legality of the JSIs, sorry. So I'll put those together because I think we're running out of time. If people could briefly comment on the MFN question and the use of WTO resources.
As I said in the first intervention, the Marrakesh Agreement does not make provision for these so-called open or flexible multilaterals, because that's the basis for saying if it is offered on an MFN basis, it's an open plurilateral, so no consensus is required. Our view is that that is not true in terms of the current provisions of the Marrakesh Agreement, because if you are bringing new rules, the provisions of the Marrakesh Agreement must be observed. And in our view, consensus will be required when bringing new rules into the multilateral trading system. Thanks, Chair.
Thank you. Anyone else want to comment on those two questions?
Well, let me make two quick comments. The first is that even in his paper this last month, Hamid Mamdouh accepts that Annex 1 agreements, adding a new agreement to that, requires there to be both rights and obligations adopted by the members. And that's not the case with the so-called open plurilaterals that are made available on an MFN basis. Likewise, a plurilateral agreement under Annex 4 is rights and obligations only amongst those parties. That's why he suggested a new Annex 5 for the open plurilaterals, which is basically a surrender of the argument in relation to those agreements. Very briefly on WTO resources and the Director General. The Director General should be playing a neutral role here and facilitating a discussion around questions of legality, not taking a partisan role as it sadly appears to have been the case in recent times in supporting or appearing to support the JSIs. And that's been especially problematic because there has been a statement that there is not enough resource to deal with many of the TRIPS waiver discussions, and people are pointing to the diversion of resources from that more important question into servicing the JSIs. Thank you.
And finally, there's a question that's specifically about the ECommerce JSI, suggesting that rather than treating data flows as trade flows, that the that issue should properly be addressed through as data flows and addressed in another forum under the United Nations. So the question really is, can some of these JSI questions be addressed in other forums?
Let me have a go at that. The UNCTAD's recent digital economy report makes this precise argument that data flows are not trade flows, so there must be a separate, it must be discussed, negotiated under the auspices of UN and not at the WTO. So I think that perhaps carries more weight than what the JSI proponents are doing. That might be one of the options. Thank you.
Do any other panelists want to comment on that question?
Maybe just to also add, I think the danger with JSIs is that increasingly issues that are not within necessarily the purview of the WTO are brought into the WTO. And we see, for example, issues such as women empowerment. Those issues are very important. As a woman, I think I would agree that we need to find a better way of integrating women into trade and ensuring that women-led enterprises are able to integrate into the global trading system. But whether that is an issue of the WTO necessarily, I would say no, given the nature of the WTO and the non-discrimination principles that underpin the WTO. So I think even in the case of data flows, developing countries have to be very careful because we are talking about a growing economy. And we know data is the new oil when it comes to the digital economy. We need to find mechanisms that ensure that we use data for digital industrialization. So to have legally binding rules that give up your access to data, which is an important resource for industrialization in the digital economy. I think those are the issues that developing countries would need to thoroughly consider as they engage in the e-commerce plurilateral. I think we have lost.
I think we have been terminated.
Oh, okay. Okay, thank you very much. This was great.
Thank you, everyone. Thank you for responding, both of you. And if any audience are there, for you to be there. Apparently we are still on, so that is great. So let me add a weenie bit in there, which is not only should e-commerce not be being dealt with in the WTO because it's not a trade issue, it needs to be dealt with in a multifaceted way that balances a whole range of issues and interests. And the problem with the JSI overlaid on that is that it's being done in secrecy. So it's not even an ordinary WTO negotiation where we had a very hard fight to get some transparency. But I know my own government, New Zealand, has argued that the document should be made public, and that has been resisted inside the JSI. So there is an unwillingness to have any level of openness and engagement that can allow those various considerations to be properly aired. So we seem to have lost Patricia. Well, should we say thank you to everybody? And it's 10 p.m. here, so I might go and have my dinner. Thank you all.